Thank you for attending today's presentation, Drug Testing and the Laws, Staying Compliant in 2025. While this session is hosted by CISA, a global leader in background screening and compliance-driven human capital and risk management solutions, we're delighted to welcome attendees from across our family of brands. Whether you registered through PreCheck, DriverIQ, or one of our other divisions, thank you for joining us. Today's webinar is presented by the Drug Screening Compliance Institute, experts in employment, drug, and alcohol screening policies, laws, and regulations. This session has been pre-approved by both SHRM and HRCI for 1 hour of continuing education unit. Thanks again for joining us today. Without further ado, I'm excited to introduce our presenters, Bill Judge and Nick Hartman from the Drug Screening Compliance Institute. Bill and Nick, please take it away.
Thanks, Antique. Appreciate it. Thanks for CISA for hosting today's conversation, and thanks for everybody that has taken their time out of the day to join us for today's conversation. A quick disclaimer that Drug Screening Compliance Institute, while we are compliance specialists and researchers, etc., we're not a law firm. Neither us or CISA intend for this information that we're presenting today to be construed as legal advice. As you can imagine, everyone's situation is going to be a bit different, so make sure that you're utilizing appropriate legal resources prior to taking any adverse employment action based off of today's information. My name is Nick Hartman. Joining me is my colleague, business partner Bill Judge from the Drug Screening Compliance Institute, as Antique mentioned, focusing on everything workplace drug and alcohol testing compliance, from policy procedures, risk mitigation strategies, and litigation support. We got a pretty packed agenda for today's conversation. We're going to talk about the shift that's pretty much happening right now with workplace drug and alcohol testing, largely driven by the rapidly changing marijuana laws out there. But in general, there's a shift from both a methodology and strategy perspective with handling workplace drug testing. We're going to focus on why this is an issue, the problem, and some statistics that we can share from you on how substance abuse is on the rise. We're going to talk a lot about the trend in marijuana user protections that, again, are more gratefully impacting workplace drug and alcohol testing programs more than ever before. We're going to talk about the tough topic and legal topic of marijuana impairment from a legal and scientific perspective. And then hopefully we'll resonate some solutions for you guys, talking about training and some oral fluid testing as a suggestion, and leave you with some action items to consider from a policy and procedural perspective to hopefully set you up for success with the changes that we see that are happening now and are inevitable on the horizon. All right. So starting with the problem, why is this an issue? And we're probably not educating a lot of people on this call, but there is a lot of substance use in our nation today. Looking at some stats from our friends at Quest Diagnostics, and Quest Diagnostics is arguably one of the largest laboratories that process workplace drug and alcohol testing, screens, etc. And every year they share what they call their drug testing index, or data that looks back on the previous years. Now we're desperately waiting or patiently waiting for them to release the 2024 stats to look on the last year. But looking at the last data, the overall drug testing positivity rate for all substances reached a 20-year high at 4.6%. Now, to put a number on that, Bill, let's give us a breakdown about that percentage there.
What's interesting and what should keep in mind is the fact that in this country, we do about 45 to 50 million workplace drug tests every year. Think about that number, and then put 4.6% to that number and do the math. That's a lot of people who are facing discipline of some sort.
Yeah, that's right. And again, it's probably not news to everybody, but you saw the different news headlines on alcohol and marijuana sales as they skyrocketed through the pandemic that we experienced. Thankfully, we're seeing a slight decline in that, but there's definitely hangover there with those users that may have turned to illicit substances to self-medicate during those times and are still suffering from some form of habit that they created or a substance use disorder, whatever the case might be. Arguably, we're going to talk a lot about marijuana today, but I want to make sure we did a call out to alcohol. Of course, alcohol abuse remains the leading cause of workplace incidents, so that definitely can't be unmentioned. With drug test or Quest DTI data, they also shared that there was an increase in both amphetamine and cocaine positives from 2022 to 2023. And in typical, I should say in past presentations, we talked a lot about opioid abuse and how they were impacting the workplace and the unfortunate results of the opioid deaths that were a cause of opioid abuse. Thankfully, with the latest DTI data, we saw a slight decrease in opioid positives. Of course, one notable exception there being fentanyl, the newer substance or more powerful substance that abusers are looking or abusing, I should say, definitely showed an increase in positivity rates.
And before you get to that last dramatic statistics there, I want to remind everybody that, first of all, the good people at Quest break this stuff down into regulated and non-regulated. It's very helpful. It's very detailed. If you're interested, you should really check out their statistics. They're just absolutely marvelous the way that they put it all together. Quest does, out of those 45 or 50 million tests that are done every year, Quest does about 11 to 12 million of them. So they're a huge player in the testing industry here. And I also wanted to mention that most of the stuff we're going to be talking about today has to do with non-regulated testing. We'll touch on some regulated stuff here and there, but keep in mind, most of what we're going to be talking about today relates to your non-regulated employees.
That's a good point of clarification because federal rules, of course, are going to supersede state rules, but state rules is where it gets complicated, right? And that's really what we're going to focus our conversation on. And in Quest's latest DTI data, they did note about a slight increase in DOT or federally regulated positive tests. So I encourage you at the end of the conversation, go Google Quest DTI and you can get access to that data. And like I said, we're waiting for them to release last year's data here. It should be out pretty soon, I would presume.
Yeah, but your last number there is dramatic.
Yeah, one of the things we pulled out of that, and I think that they highlighted it on purpose, is for the first time ever, they shared drug testing data with regard to cheating of urine drug tests. And the stat was pretty glaring, showing that cheating with urine drug tests surged more than 633% year 2022 versus 2023. What that means is that an incredible or very noticeable and shocking increase in people that have been caught trying to alter, adulterate, or essentially beat the drug test as far as urine drug testing is concerned, whether they brought a device in, whether they tried to substitute someone else's urine, whether they had a synthetic urine product, but they're getting caught at the collection sites or by the laboratory's testing capabilities to determine that it was a falsified urine drug test. So that definitely puts a glaring caution flag on urine drug testing, and we're also going to elaborate on that throughout the rest of the presentation. All right, so that's just in general terms. We're going to shift the conversation to pick on marijuana for a moment here. Again, in the Quest Diagnostic DTI data, they showed a marijuana positivity rate in the general workforce increased over 45% from the last 5 years with the latest data. Not surprising to us, but should be noted that for post-accident tests, marijuana positives increased 114% dating back to 2015. And Bill, do you want to give a brief synopsis on our belief? And I think Quest verified that's correct.
Yeah, we had written about it and we had talked about it before this statistics came out, but Quest agreed with our assessment actually that the reason for this dramatic increase in post-accident testing is because so many employers are dropping pre-employment testing. Whether that's an appropriate thing to do or not in your workplace, just keep in mind that marijuana use is up dramatically and it's going to show up in your workplace testing program somewhere.
Yeah, it keeps our phones ringing off the hook. Employers are trying to explore how to be creative and comply with these new changing laws or the new idealistics. The fact that marijuana is a growing popularity as far as its use is concerned, and trying to determine whether they should remove it from testing panels or remove it from post or pre-hire testing, etc. And here's your cause and effect right there. We're already seeing the evidence of it. Putting your proverbial head in the sand and avoiding the issue pre-hire certainly doesn't solve the problem. It just pushes it to a post-hire issue.
And I might mention that there's a huge difference between limitations state by state on testing for marijuana versus taking action when there is a positive. There are only about five jurisdictions that limit or prohibit pre-employment marijuana testing. The statutes typically say that employers cannot discriminate against someone who uses. Okay, that's a huge difference. You may want to be able to test And then when there's a positive, determine what to do next and whether you have grounds to dismiss or not hire somebody based on what they do, based on the safety sensitive nature of their job.
That's a great point, Bill. Discerning testing versus discipline. There's two different things in the statutes. Like you said, there are very few limitations on employers today on actual testing for cannabis, and we'll definitely get into those details. But disciplining them based off of positive results is an entirely different thing. So a couple other stats from our friends at Forbes, Hound Labs, and the American Addiction Center showed that 85% of marijuana users admitted to driving the same day that they consumed cannabis products. Surprisingly to me, 48% admitted to using marijuana at work, whether it be a lunch break in the parking lot, whatever the case might be. For those employers on the call that have remote workers, in a study by the American Addiction Centers, 40% of respondents said that they used marijuana either before or during work hours for remote
You and
work.
I had a conference call with a customer, about 12 people on the line, and there was one fella that had a bong sitting right over his shoulder, and it was actually still smoking. I don't know.
He clearly didn't have his screen blur on and got caught red-handed, quite frankly. But then ask yourself, if you're a remote manager or a manager handling or supervising remote employees, how do you handle that situation from a reasonable suspicion perspective? So that's definitely a head scratcher for sure. And then last, there are 31% of cannabis users admitting to using marijuana while on their way to work, which I think is something that's happened for many years past as someone who's preparing to go to work. But I think everybody can agree we don't really care what people do on their free time, but we absolutely do care what brain they're bringing to work from a cognitive and physical aspect so that they are not a safety concern in the workplace.
Absolutely.
So that's just a few stats again showing the problem. Substance use is on the rise. It's very clear from the evidence that a record number of people are testing positive for illicit substances, and these are gainfully employed individuals in our nation's workforces. So now we're going to transition into the trend that we're tracking very closely on marijuana user protection. So if we'd had this conversation a decade ago, most marijuana laws or marijuana testing was completely permissible and had no impacts on the workplace whatsoever. And that has adversely and very quickly changed. Bill, you want to cover where we're
Yeah.
at today?
Yeah, and keep in mind that we don't have these protections for other substances like cocaine or opiates or just marijuana users, okay? And currently, we have 38 states that authorize the medical use of marijuana. 24 states authorize the adult use of marijuana, and 18 states authorize the medical use of CBD or cannabidiol. Some states, like Iowa, call it low THC, low dose THC. The language of these various states varies different dramatically. So you got to be real careful state by state what the language of the state statute actually says, how it describes things, how it defines things. So please be careful as you move from state to state.
Yeah, we're going to get into those details and those differences so you get it. You saw the poll pop up if you want to respond to that. Curious to see if your organization currently has a drug testing policy in place or not. And we'll certainly start stressing the fact that if you're an employer conducting workplace drug and alcohol testing, you almost cannot afford to not have a drug testing policy in place to cover yourself, considering all these dramatic issues. But to Bill's point, there's really no two states that are alike with their laws, whether it be the adult use of marijuana laws or the medical marijuana laws. Some state laws have zero impact on the workplace, while others dramatically impact the who, what, when, where, why, and how you can test. And that's really going to transition to our next slide here that talks about states, municipalities, meaning at the city level, are either implementing or amending their marijuana laws that are now more so than ever before, including employee protections for their lawful use of these products while not at work. And again, this impacts who you can test, what substances you can test or you must identify, which we'll get into in a minute here, when, where, why, how you can conduct testing, and what disciplines can be imposed on job applicants and your current employees. And I mentioned some legal words here like lawful activities, lawful products, off-duty use, at work will be another term you're going to hear. And these are terms, while Bill is a lawyer, we're not trying to use big words here. These are words we're taking right out of the state statutes and state regulations, but they have incredible impacts on a timing perspective from employer testing. And we'll get into that here in just a quick moment. But one thing also we're going to cover in great detail is the trend in state laws that now are really breaking down a marijuana positive to more than just a marijuana positive. They're now discerning between delta 9 THC, the psychoactive substance in cannabis, and then non-impairing marijuana metabolites.
Yeah.
Uh,
In fact, we've talked about this quite a bit lately, Nick, and written about it. And I believe that it's no longer appropriate just to simply say you've got a marijuana positive.
yeah.
I think you have to be very specific. What metabolite are we talking about? Are we talking about delta 9 THC or carboxy T? What metabolite are we talking about? And the reason for that will become very obvious here in the next few slides.
Yeah, so just put that in your brain right now. Non-impairing metabolites of cannabis, because that's going to come up in our conversation. And we're going to dive deep into what the heck that means from both a legal and scientific perspective. Now, I'm going to pause the conversation just for a moment and talk about medical marijuana considerations. Medical marijuana, of course, is a little bit different than the adult use of marijuana in that, well, of course, marijuana is still a Schedule 1 drug. There's no ADA protections because, of course, ADA is a federal protection, which doesn't qualify here. However, each state have human rights laws and disability discrimination laws where somebody who is authorized to use medical cannabis under that state law could bring a claim, and we've seen evidence of them bringing a claim protecting their underlying medical condition for which they use or are
Right.
authorized to use medical cannabis. There are some states that limit, again, what you can do based off a positive drug test, especially for a medical marijuana patient. Some states say you can't actually take any action at all, which South Dakota bill says that in their
Yeah.
medical marijuana law that it must be treated like any other prescribed medication.
Yeah, and they get very specific in South Dakota. It says that those who are medical marijuana patients, approved medical marijuana patients, must be treated in their relationship with their employer or with drug testing the same as anyone else who's on a prescription medication.
Yep. And another poll popped up there just regarding on how often you review or update your drug testing policy. Curious to see what kind of cadence you guys are in. Certainly is what this is something that you don't haven't looked at in a couple of years. You absolutely need to do, and we certainly suggest at least taking a look at it each year with how fast these laws are changing and how impactful they're becoming.
If you
Uh,
haven't looked at it in the last couple of minutes, you might want to take a look.
There are also laws that prohibit you from discriminating against someone's status as a medical marijuana patient.
Absolutely.
If they disclose that during the hiring process, you can't simply deny them employment because of the fact that they are a medical marijuana patient. And then another term I mentioned earlier, off-duty use. Some medical marijuana laws prohibit an employer from discriminating against someone's off-duty use of medical marijuana. How the heck do you discern
Yeah.
whether that use was off-duty or not? We're going to get into that. Really, our suggestion here for dealing with medical marijuana is make sure you are prepared whenever this rears its ugly head, that you're prepared to have an interactive conversation with that individual, a conversation of sorts to see if their underlying medical condition for which they are authorized to use medical cannabis can be reasonably accommodated in the workplace or not. You can take your job descriptions, for example. Hopefully, you have comprehensive written job descriptions. You can provide that to a medical marijuana patient, have them take that job description back to their certifying medical physician that authorized them to use medical cannabis, and have that physician sign off that they could safely conduct the essential functions of that job or not while being under their care. And Bill and I, tongue in cheek, say that 99.9% of the time those doctors won't sign off on that.
They will
Well,
not. But you also have to consider the fact that even if the state statute isn't as specific as South Dakota, for instance, you've got a lot of courts that have interpreted their state's laws to protect or at least allow for a medical marijuana patient to pursue protection under other states' laws. Take, for instance, the state of Massachusetts. They had a case recently known as the Barbudo decision, where the court found that the employee did not have a cause of action against the employer under the state's medical marijuana law, but the Supreme Judicial Court said, okay, but you might have a cause of action over here under the state disability discrimination law for your underlying use of that substance or your underlying medical condition related to the use of that substance. So you got to be really careful and not only check the state statutes and regulations, but what are the courts in your state saying?
yeah. It's a great point because they all play together, right? And really, the whole point here is that make sure that you've taken that additional step before blindly or procedurally just terminating someone or declining employment. Make sure you have that interactive conversation before you take adverse employment action. And another poll that popped up, what is your organization's stance on cannabis use among employees? I love the fact that we still can have zero tolerance policies, although that needs to be discerned on a state by state basis. If you have a nationwide zero tolerance policy, you're probably not in compliant and probably a litigation target as we sit here today. Just thinking about how impactful and how different these laws are by state. And here's a perfect example of that. There are currently 28 states right now that, in the letter of the law, limit employer action where an employee uses or is under the influence at work. And Bill, there's a lot of legalese to unpack there.
I got to be honest with you. There's 10 additional states that have specific language about protecting off-duty use of marijuana and defining marijuana as a lawful substance under their state's existing statutes. But then you have these 28 states. And if you're in one of these 28 states, please take a close look at it, because the law says that employers can only take action if they find an employee to be using or under the influence at work. At work. Okay, so the question is, how do you do that?
Yeah, it's a legal dissertation, right? Now we have to define that from a practical testing perspective to meet the letter of that law. So that segues next into marijuana impairment. It's a very powerful word. It's a very legal word, but let's start with the facts here, Bill. We know as we sit here right now, there's no methodology, there's no per se testing limit, there's no device that can determine if someone is impaired or under the influence of marijuana at that moment.
Now, let me point out, a lot of people will interrupt us at this time and say, yeah, but what about the states that have per se limits or levels of impairment for DUI? Okay, DUI is a whole different universe. That is the criminal side of the legal universe. That's not the workplace side. That's not the civil side. And there are, in fact, a lot of states that have set certain levels where, like with the 0.08 for alcohol, it's presumed you're impaired or intoxicated. That really has nothing to do with the workplace.
And you'll see that if you look into those cases, they're actually being challenged and overturned because they're looking at
Yes.
for non-impairing cannabis metabolites. That's starting to rear its ugly head there. But to your point, Bill, state DUI, D per se limits aren't reflective into the workplace.
Right.
So again, with a lack of an opportunity or a methodology or a device to definitively say if someone's impaired or under the influence right now, how do employers meet the letter of the law and still comply and have a robust testing program? Again, as you mentioned, our focus today is on state laws, not really federal law positions where marijuana is still illegal, still is tested, and a marijuana positive violates federal laws in most all cases. But essentially, as you mentioned also, Bill, we can no longer say from a non-regulated perspective that the drug test was positive for marijuana. It's going to require you to discern a little bit more. And real quick, the last poll that we see up on here, are you aware of your state's laws regarding protections of off-duty cannabis use? This is an incredibly fast changing topic, keeps us super busy on a research side and monitoring all the news wires and legislative efforts that are happening throughout the year, because this is changing fast both at the state level and even at the city and municipal level. But let's try to bring some practicality to this, Bill. I know you're a lawyer. We'll take a quick risk here and have you give us a science lesson on how cannabis breaks down in the body once it's used.
I wouldn't say that I'm qualified as a scientist, but I was dumb enough to own a laboratory for a while. So maybe that gives me some license to talk about these things. The changes and the legalization of marijuana causes us now to be very careful about talking about impairment and whether or not somebody was just positive for marijuana versus the metabolites. And here's what we're talking about. There are a lot of states that say that you can't act unless you're acting based on a metabolite that's an impairing metabolite. All right, let's look at it. If you use marijuana, the body breaks it down first to a substance called delta 9 tetrahydrocannabinoid, or THC. Look at that chart, that top item. That's a psychoactive metabolite of cannabis. Okay, that breaks down within a matter of hours and is gone from the body, but it breaks down into another psychoactive component called hydroxy THC. So you've got delta 9 THC, you've got hydroxy THC, and then that breaks down within a matter of hours to what's called carboxy THC. Okay, that's what's typically found in a urine drug test, but it's not psychoactive. That's the problem here. We have used urine testing since drug testing began in the late 1980s. I was there. Yes, I'm old. But you got to remember that when drug testing started back in the mid to late 1980s, it was specifically designed to determine if someone had recently used an illegal drug, marijuana, because it's still illegal under federal law. But as we've seen, it's no longer illegal under a lot of states, 24 for adult use, what was 31 or whatever for medical use. So you have to be real careful about what your state law says. But that's how marijuana breaks down in the body. Within a matter of hours, the psychoactive metabolites in the body are gone. So
Yeah.
this tells you you've got to be real careful about what test methodology you select, urine versus blood versus oral fluid. You got to be careful.
As you mentioned, Bill, drug testing from its inception was really to detect the past use or presence of illicit substances. We weren't trying to discern whether it was recent use or impairment or under the influence or any of those legal words. Now, if you break down the science of, especially with states that are now discerning between non-impairing cannabis metabolites and impairing cannabis metabolites, here's the science. Again, this is fast-changing stuff, but quickly delta 9's out of your body. It doesn't matter if someone smokes it or ingests it. Of course, it'll depend. Someone smokes it's going to have a quicker onset and a shorter duration. If someone eats it or drinks it, it's going to take a little bit longer for the onset, but it'll have a longer duration of the high. So that's why there's some variables there. Also, detection time periods will vary on specimen types, as Bill mentioned. We always used urine to detect carboxy THC at the lab because it was there. It sticks to your body fats. It sticks around in the user for several days, weeks, months, depending on frequency of use, potency of use, all the rest, that type of stuff. There is a shout out here to oral fluid testing, which we'll cover a little bit later in the conversation, but it really is part of the solution that we're going to focus on. Now, we talked about, I think we hit all these already, the presence of substances. Yep, carboxy being a fat soluble impairing substance in hair, urine specimens, and the fact that oral fluid testing, and then obviously we have to mention blood testing too, although it's invasive and expensive, are the only two methodologies that exist today that can discern between carboxy THC and delta 9, identifying specifically delta 9 THC.
Here's a sort of revolutionary statement that I'll make, in that most of you are probably still using urine to test for drugs in your workplace program. Urine testing cannot detect delta 9. It only can detect carboxy, the non-impairing metabolite.
Yeah. And again, as we mentioned here, with all the evidence, with the science, and with the legalese now, carboxy THC is being outed a metabolite of cannabis that is non-impairing and it does not indicate impairment. So again, I'll just make a reminder: there's no methodology, there's no per se limit, there's no device or anything else like that exists in workplace drug testing that can determine if someone's impaired or under the influence today. And delta 9, as Bill mentioned, also is only identified in oral fluid specimens. So, harping a little bit more on the legalese of impairment. The reason why I bring it up is because I want to show you some examples of some state law and some case law examples that are driving this point home and creating confusion or complications for employers managing their workforces. You see here 6 states that specifically address cannabis impairment in their statutes and regulations. Where I sit here in Washington and in the state of California, a new law went into place that prohibited employers from taking action on a marijuana positive that they also contain non-psychoactive marijuana metabolites, meaning carboxy THC, carboxy THC positives. Washington's law is specific to only pre-employment testing. It doesn't apply to post-employment testing. And California's law applies to all reasons for test. So if you're a California employer, you're utilizing urine drug testing and taking adverse employment action on a marijuana positive, you need to reassess your program because you're not in compliance with that state law today.
Unless you're in a building, trades, or construction workplace,
Glad you
because those
mentioned that,
are
Bill.
exempt from the California law.
I'm glad you mentioned that. Most, if not all, of these marijuana laws and statutes, regulations that we're talking about today have some form of safety sensitive carve out or exemptions to the law, specifically or most commonly for either industries or specific job types, safety sensitive job types. In California's law, it was only specific to the building and construction trades. I know they're working on adding law enforcement first responders to that bill. And in Washington, it was a little bit more robust, included like the airline industries, first responders, law enforcement, those that are authorized to use or carry a handgun. And then letter G, if you scroll all the way to the bottom of the exceptions list, letter G was jobs where impairment in the workplace could cause death. And of course, it does also go on to say that you must have that specific annotation in your job descriptions that it's considered a safety sensitive job and that if impairment could cause death or injury in that case. So again, some important details to find there. But Bill, talk about Arizona, Connecticut, New Mexico, and Delaware, would you?
Yeah, very interesting because everybody was up in arms about California's law, AB 2188, when it first came out. And oh my God, how do we test for Delta 9? And there's no way to do it and everything. They should have stepped back and realized it already exists in some states like Arizona, Connecticut, Delaware, New Mexico. Like, for instance, in Arizona, it says a medical marijuana patient may not be considered, quote, under the influence of THC solely because of metabolites. I love this, in insufficient concentrations to cause impairment. What is that? No, no one knows what that is. Then in a case recently, the employer tried to show that 100 nanograms of THC meant that the person was obviously at a level of concentration of impairment. And the court said, no, that's not quite it. Nobody knows what that means. Connecticut, their law says a test result that reveals only carboxy THC shall not form the sole basis of employment action. And there are exceptions to that. But what does that say to you? That says to you that you can't use urine testing. Now, the drug testing statute in Connecticut, understand, only applies to urine testing. So I'm not quite sure what that means. New Mexico's law, the employer says that the employer may discipline and terminate based on any Delta 9 THC positive. Okay. What does that tell you? In New Mexico, if you want to discipline, fire somebody, you better have oral fluid test results that show Delta 9. In Delaware, a registered qualified medical marijuana patient shall not be considered under the influence solely due to the presence of metabolites of THC. Okay.
Yeah. So
you've got to be careful to look at state's law.
That's exactly right. Those are just a few examples that exist out there where states are making state law are discerning between a carboxy THC positive and a delta 9 THC positive. That's why, again, driving Bill's point home, we can no longer say you have a marijuana positive. You need to know exactly what analyte or metabolites being screened there and whether that applies to a state law or not. So those are some state law examples. Let's talk about case law, Bill.
And yeah, the statutes aren't the only place where there are limitations. You got to look at the state's courts to see how they've ruled on these issues. And as early as 2010, Michigan law courts said that carboxy THC is not a controlled substance. Think about that. Go back and look at your policy language. If your policy says that you can take disciplinary action based on a positive for a controlled substance, THC or carboxy THC doesn't give you that authority. You understand? So be careful. In Idaho, that does not have a marijuana law at all. In Idaho, I'm sorry. Here, I just lost you guys. I was trying to get rid of that survey. In Idaho, a court found that carboxy THC is non-impairing. It is, in essence, the court said, a negative test. In Arizona, in a case called State versus Harris, carboxy THC was found to be non-impairing. It is not considered a metabolite as defined by the legislature. And in that case, the court overruled and overturned a DUI conviction. Now, there are other states that have looked at it a little bit differently, like in Ohio. The court in State versus Schultz said the legislature established a presumptive intoxication level, 35 nanograms, which is pretty high compared to the 15 nanogram cutoff for a positive test. Under DUI or OVI law in that state, establishes functionally impaired level. Okay. In Iowa, the court said that the legislature specifically criminalized cannabis metabolites. Okay, that's their position. States differ. You got to be careful.
I think that Ohio law could be easily overturned with you see some case law that's happening, and as the science develops from detecting cannabis, and really if 35 nanograms per milliliter really is in urine indicative to impairment. So again, this is fast changing stuff, but showing you from both a state law regulation statute perspective and also case law example how the trend is in going in the direction where we need to discern between a cannabis metabolite or not. Let's take a look at from a state law
Yeah.
example. We talked about impairment. We talk about using like the word under the influence. Some states actually define what impairment is, and in Illinois is a prime example.
Yeah, there's two states that we're going to show it to you here now, Illinois and New York, that have done you a favor in their adult use of marijuana statutes and basically defined what impairment is. Here, the Illinois law says that an employer may consider a registered qualified patient to be impaired when he or she manifests specific articulable symptoms while working that, and this is critical, it's going to require proof, that decrease or lessen his or her performance of their duties or tasks of the employee's job, including symptoms of the employee's speech, physical dexterity, agility, coordination, et cetera, et cetera, et cetera. Basically, we're talking about reasonable suspicion, signs and symptoms. And in Illinois, it also includes, if you read down on accidents and injuries. That can allow you, and this stuff should be in your policy, but that can allow you to demonstrate that a person was impaired by marijuana.
Yeah, and I highlighted obviously that first bullet point there goes showing reasonable suspicion is essentially actionable to make that legal assertion that someone could be potentially impaired under the influence of an illicit
Yeah,
substance.
I
So
love the sections in there though that decrease or lessen performance. Okay, how do you
yeah,
prove?
what yeah,
How do you
and carelessness that results in an injury, exactly. All
yeah,
the rest that
I love
unfortunate
that
results and all
carelessness.
that.
Yeah, you were
Yeah.
careless. That yeah.
Let's talk about New York real quick.
In New York, real quick, it's very similar to Illinois in the law. In people sometimes think that based on a guidance that was put out by the Department of Labor, but sometimes people think you can't test for marijuana in New York at all. They're wrong. You can test for marijuana in New York when there are, as this section here says, signs and symptoms. So section 4A of the Labor Code says, notwithstanding the previous limitations, the employer may consider an employee is impaired by the use of cannabis, meaning the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance. Sound familiar? Or let's see, performance of the duties or tasks assigned to the employee of such job specific articulable symptoms interfere with an employee's obligation to perform a safe and healthy workplace
Yeah,
free of
got
the
it. Yeah.
recognized hazards as required by state or federal occupational health
There's a
and
lot,
safety.
lot of
So
legalese in there, but really what we're
it's a lot of
focusing on,
mumbo
right?
jumbo, but
Yeah.
basically what it means is signs and symptoms of possible marijuana use. Okay. This is specific to marijuana.
And you use, there's some words there, right? Contemporaneous, specific, articulable. That means it's
Performance. Yeah.
something that's happening now, something that you can see, something you can explain, something you can write, which we'll get into here in the next
It
couple of
just
slides.
cries out for supervisory training, doesn't it?
That's exactly right. And that really brings us into our next topic, which again is how do we solve this problem? What solutions are available? What strategies should employers adopt to deal with these changing laws? And quite frankly, we have to lead this conversation with reasonable suspicion training. If you're not providing reasonable suspicion training for your managers and supervisors, empowering them with the tools that they need to confidently and accurately recognize signs and symptoms of workplace substance use, and most importantly, what action steps to take in the heat of those moments and to deal with potential conflict in those situations, you're missing out on a great opportunity. And we certainly would encourage you to do that going forward. Build reasonable suspicion is permissible in testing in every state out there.
Absolutely. And we do a lot of training and have over the years. I've been doing this almost 40 years and been doing training on the concept of reasonable suspicion for a long time. And the Supreme Court has defined reasonable suspicion as something more than a hunch. Okay, what the heck is that? You have to have some fact or facts. It can't be just a hunch. You have to have some fact or facts that get you beyond a hunch. And that's what reasonable suspicion is. You don't have to have proof that the individual is intoxicated or falling down drunk, just something more than a hunch. And then you can take action. And if you don't take action, that's where the liability might fall in.
You're absolutely right. We've got cases where employers are personally held liable for their actions or their lack of actions in these situations. So it's incredibly impactful. But that's why we always encourage training. That's one of the best investments you can make for your company. Utilize some kind of a checklist so they can document the heck out of the situation from start to finish in case they are ever asked to testify in a situation and try to recall what happened several months or several years later potentially. But again, one of the best tools you can implement in your program, just again dealing with the changing laws that are happening today. We also are big proponents of oral fluid testing. This is something that oral fluid testing has been used for decades in workplace drug testing, but is certainly gaining in popularity for many different reasons. And I'll just cover a few of these here. The fact that you talked about the urine drug test cheating and how it surged 633% year over year. Oral fluid testing is almost always an direct observed collection. You're right in front of that individual, you're in a controlled environment. There really is very limited options for cheating an oral fluid drug test. So you almost virtually eliminate that issue. Oral fluid testing, as we mentioned before, is the only methodology aside from blood testing that can identify delta 9, THC, and no other cannabis and non-psychoactive cannabis metabolites. There is some notations at the very bottom there that please check your state laws. Some states specifically define what specimen is. Bill mentioned Connecticut's law only referring to urine testing. Some states may limit or prohibit the use of oral fluid testing or other specimen types. Some states may also limit or prohibit the use of instant rapid POCT collection devices. They may require lab-based testing, so make sure you discern that. And also, last point here is to make sure you also understand the cutoff level differences between lab-based testing and instant testing devices. Some labs have a 4 nanogram per milliliter or a 15 nanogram per milliliter cutoff for marijuana. Some instant testing devices have a 40 nanogram per milliliter cutoff level, so 10 times the amount before it triggers a positive.
Yeah,
And
the federal government, I think you mentioned, has approved oral fluid testing. We haven't quite got there in practice yet because they're waiting on approval of 2 laboratories, actually. But their nanogram cutoff level is 4
that's right.
nanograms per milliliter.
Yeah. And to take that further, Department of Health and Human Services, and then of course the DOT that has to comply with HHS, vouched for the science of oral fluid testing and equating to that equal to that of urine drug testing. So you have a court defensible, upholdable screening methodology that again tests specifically for delta 9. You'll see the 4 nanogram per milliliter cutoff level that the DOT has chosen once they implement this program. We will caution everybody that oral fluid testing, while it is authorized for use in DOT regulated programs as an alternative specimen method, the implementation of that program is currently on hold while they certify laboratories and get the right devices deployed out there. So that's all on hold till further notice, but it is coming. And then lastly here, as we mentioned already, oral fluid and marijuana laws. Oral fluid is the only methodology that can discern between a delta 9 positive and a carboxy positive, which meets the laws in several different states. And again, with case law regarding the legality of carboxy THC. All right. Want to make sure we have some time for some Q&A, so I'm going to leave you guys with some action items to consider from both a policy and procedural consideration, hopefully to limit your liability as these laws change rapidly. If you don't have a policy in place today, if you haven't taken it out of the top desk drawer in a few years and dusted it off and revised it, please put that on your to-do list.
If you know where it is, yep.
Yeah, exactly. You really can't afford to operate with these, especially considering all the court case law that's happening here. It's a free insurance policy for you. So make sure you have a comprehensive policy. Make sure that it obviously complies with all the state's laws, local laws, case law that apply to your program. Make sure you have complement the policy and consider what action you're going to take with marijuana positives. And you don't exactly have to terminate. There's no drug testing law out there that says you have to terminate someone based off of a positive drug test. Employers are considering things like second chance agreements, leveraging their EAP, employee assistant programs, or opportunities for employees to go get treatment and have a pathway to return back into the workplace. Make sure you consider those as alternatives to just blindly terminating somebody. Make sure you also have sound processes and procedures that complement the language within your company policy so that your managers and supervisors who are enforcing your policy know exactly what action steps to take in the heat of the moment. It's a prime time to take a look at the different testing methodologies that exist out there. And that may differ what you utilize, what panels you utilize, or what method you utilize pre-hire from post-hire, again, largely to comply with the new changes in these laws. And again, we're going to harp one last time on providing your managers and supervisors with training, how to recognize the signs and symptoms of workplace substance use, training on what the details of your policies and procedures are. So again, that they're 100% in tune with exactly what you're requesting of them and that they have the tools to do.
Yeah, I would insert here that having a policy is one thing, but having procedures and training your managers to those procedures is a whole different thing. So
Yeah.
pay a lot of attention to the procedural aspect of what you're doing.
Yeah, the last poll here, we're curious to hear what your biggest concern is when it comes to drug testing, whether it's all these scary laws we just got done talking to you about, whether it's upholding safety within your workplace, manage how you manage positive results, etc. To take a quick moment with that. And then the last 2 points here, we talked about job descriptions, we talked about safety sensitive carve outs or exemptions to these laws. Please make sure you have comprehensive job descriptions written. You can't just say we're a warehouse and all our employees are safety sensitive. It's not the environment, it's the specific job role. So make sure your job descriptions are incredibly detailed and they detail the actual essential functions of each of those jobs, not for if, but when you're ever challenged in the court of law there. And then with regards to medical marijuana specifically, make sure again you're prepared to have that interactive conversation, determine if someone's underlying medical condition can be reasonably accommodated in your workplace or not prior to taking any adverse employment action. All right. Sorry I had to rush through some of that stuff, but again, I want to make sure we had time for your questions. So I'll go ahead and turn it back over to Antique and see what we got in our Q&A here.
We are an employer located inside a federal installation. Do we follow state or federal laws?
Typically, what you'll do if you're a federal grantee or contractor, you're going to be required to follow federal rules. As a result, you test for marijuana. You can test according to federal guidelines, which means urine testing and soon, hopefully, oral fluid testing. But if you are a federal contractor or grant recipient, you follow federal rules.
Yeah, there's actually a few questions along that vein, right? If we're federally funded, are we exempt from marijuana laws? And then companies with DOT desk drivers, et cetera. So you have to make that discernment, right? You're going to have to discern it from those that are federally regulated and those that are non-federally regulated and have rules that apply differently. And maybe even in your policy, you have a non-DOT policy, but you have an addenda that addresses your federal contract workers or your federally regulated DOT workers as well. And to Bill's point, for those that are safely or those that are performing that safety sensitive job function regulated under DOT, for those that are specifically working under a job that's covered by a federal grant or contract, you can more than likely find exemptions to the law, but that may not apply to all of your staff.
Correct. Yeah. The grant or the contract only applies to those actually functioning under those grants or contracts. So make sure everybody that considers themselves a federal contractor, they're surprised when we talk about this because they then realize, oh my gosh, we've got non-federal workers. We've got to have policies for those folks too.
And remember, for DOT testing programs, for federal testing programs, there is no excuse for a marijuana positive. The DOT put out a letter regarding the adult use of marijuana, medical use of marijuana, as well as the lawful use of cannabidiol or CBD products. stating that anybody arguing that fact will not be justification to overturn a marijuana positive, as again, it's still federally illegal.
Next question.
Here's another one. When testing with reasonable suspicion in the state of California, if there is a positive in a UA test, is termination an option?
It is an option, but you've got to be able to demonstrate that you've got or proved to have a psychoactive metabolite of cannabis. Okay. So what does that mean? If you drug tested somebody in California, and let's obviously assume you're not in the construction or building trades industries, which are exempt from that law, but if you used urine testing, you're going to be subject to attack. Why? Because we said earlier, urine test can only reveal carboxy, the non-impairing metabolite of marijuana.
Yeah, so I would definitely take caution, especially in California. Again, their law is specific to requiring employers to screen for or identify Delta 9 THC for all reasons for test. So urine is out the door in that perspective.
And we don't have any court decisions yet under that new law. We'll wait and see what they say, but that's right now, that's what the statute actually says.
And there was another one that just came in about, are you suggesting there be two policies in place for someone that is grant paid or not, right?
There, you can no longer have a single company policy, period. End of story.
Yeah, so that's why we suggest maybe having a core non-regulated policy and then having a state policy addenda to address state laws, but also a federal addenda to the policy for those that are federally regulated employees or federal grant recipients that discern the different rules that apply.
Exactly. I won't say there aren't any, but there are almost no situations where you can have a single company policy anymore.
What about healthcare workers? Can the employer terminate a nurse, per se, if they use Delta 9 on their own personal time, for example, in Georgia?
Depends on the state, obviously.
Yes.
Depends on the rules of the state. You can't in Minnesota. In Georgia, there are no limitations in termination. But one thing that you also might want to consider is there may be reporting requirements for nurses. You may have to report that positive to the state licensing board.
Here's another one. We are a drug and alcohol treatment facility and are federally funded. I believe this allows us to not allow staff to be under the influence of marijuana.
There's a lot of questions about if you're simply receiving federal funds, Medicare, Medicaid, whatever, versus actually operating under a federal grant or specific federal contract. You need to check into that very carefully. Just the fact that you receive some federal funds for parts of your operation doesn't necessarily mean that you are a federal grant recipient or federal contractor.
And that definitely would be an issue you got to look at by state as well. So
yeah, you need to take care of, really look into that carefully.
All right, Bill and Nick, I'd like to thank you for being with us and providing us with such an informative and timely presentation. To our attendees, if you have any questions about our drug testing solution, you can scan the QR code on your screen right now to contact one of our screening experts.